Good morning, everyone. Thank you for being here with us today, for joining us for the employer workshop on how to hire individuals with justice involvement. I just want to let everyone know that this workshop will be recorded and will be posted on the Suffolk County Department of Labor website. If anyone has any questions during the workshop, you may enter them in the chat and we will relay them to the presenter. Now I'm going to turn it over to our Commissioner, Rosalie Drago.
Good morning, everyone. Thank you for attending. There are hundreds and hundreds of jobs open, as you know, and we have had amazing success working with different populations of people who live in Suffolk County who want to work and who have received training to work. And so we run a series of these workshops about those different populations today, focused on people with justice involvement. We will, if you would like, afterwards can connect you with employers that do hire for some one-on-ones. They just don't often present on these panels, but are willing to have one-on-one conversations with you. And we are so fortunate to have Liz Justison here today to talk about how that can work out for you and the things you need to know. So Liz, thank you for joining us. And we look forward to working with you in the future. And I'll turn it over to Liz.
Thank you so much, Rosalie, and for the Suffolk Department of Labor for providing me this opportunity to present today. I'm very passionate about folks in reentry and those who have come through the court systems. And today's presentation, I have to provide some context. So I'm not just going to give you the facts on what it is okay, when it's okay to hire someone with a criminal record, when it's not. I want to provide you some context of the criminal justice system, how people get kind of pulled into it, and then the difficulties that they have once they have come through the system, whether it be with a sentence of probation or jail. We'll talk a little bit about that and what those different sentences mean, as well as some of the post-conviction relief that you may see on rap sheets or be provided by the potential employee. And then we'll talk about negligent hiring and what your responsibilities are under the law when you are considering hiring someone with a criminal conviction. So I'm going to bring the presentation up right now. And let's talk about providing second chances. So what's important to understand is that 1 in 3 adults in the United States has a criminal conviction. It's about 2.3 million people across New York State alone. And we've seen a dramatic increase in the number of people that have come through the court systems, particularly since the 1970s, with policies such as tough on crime, war on drugs, 3 strikes, mandatory minimums, broken windows policing, really have brought many people in. And we're not talking about an exorbitant amount of felonies. We're talking about even lower level crimes, when we're talking about misdemeanors and not necessarily violent misdemeanors, petty larceny, jumping turnstiles in the city. Cases out here include criminal trespass, things like that. And some of them are victimless crimes in the sense that maybe the person's the victim in the sense that they're using drugs, so drug possession, things like that. In New York State, actually the number's gone down. We've decreased the incarcerated population to about 38,000, which is significant. So that means there's more people home, some on parole, some without supervision. But there are still another 20,000 people going through our local jails any given year, even with bail reform. There are still plenty of people coming through our local jails, and even those small jail sentences or small stays pending some kind of outcome in the criminal court can have dramatic impacts on people who are caught up in the system, potentially losing their jobs, losing their families, falling behind in their bills. And one of the biggest things that people should be informed about are rap sheets, the report of arrest and prosecution, which is the summary of a person's criminal convictions. And not all rap sheets are created equal. And that's really important. So depending on what type of background check, honestly, you may be getting information that you're not supposed to get. And the legislature and our lawmakers have decided there are certain types of charges you shouldn't be advised of because they're not relevant to employment. They're not relevant to housing or the ability of someone to get a bank loan. But unfortunately, because there's so many background checks available, this becomes very problematic for the client if you find out about their youthful offender adjudication or a violation that's not properly sealed. Some other things you should know about is that most people are not found guilty beyond a reasonable doubt, which is when you watch Law and Order or CSI, that's what you see, right? People are found guilty beyond a reasonable doubt. And we have this grand notion that that's what happens. The reality is most people accept some kind of plea bargain, even when they are innocent. And I know I'm a defense attorney, so I know that probably it is somewhat biased, but the reality is, even innocent people, I know that I've pled them guilty because they can't keep coming to court. They can't take another day off from work. They're willing to take a sealed violation, which is non-criminal, and just pay a fine because they have to get it over with. And maybe you're sitting there saying, I would never do that. But if you're stuck in on bail, you might do that. You know, I've had plenty of cases where someone's in on $15,000, $20,000 bail, and there's no way their family's going to afford that. We talk about their case. I think they have a defense. They were illegally stopped or illegally searched. And the problem becomes that I get an offer from the district attorney for 30 days. They have 6 days in. On 30, you do 20. You have 14 days left if you have 6 days in. And with the weekend, they're going to get out in 12. Or they can take their case to trial and prove their innocence and prove that they were wrongfully stopped. But that's going to be 7 or 8 weeks from now. And clients will want to go home. And that's the reality of what happens. Now, of course, there are people that commit crimes and they need to be held accountable. But if people can't post bail, they're more likely to accept any plea deal that's offered that will get them out of custody. And there are sweetheart deals that are offered in those first couple of days that someone is in custody that really, borderline coerce people to accept them, just as the example I showed you. And what's important to understand is that we shouldn't even be looking at arrests because 1 out of 3 arrests don't even result in any kind of conviction. And most people who get arrested the first time or have minimal contact, they're not going to plead to the top charges. Most of the time it's plea bargain down for a myriad of different reasons: the strength of the evidence, mitigating circumstances, some defenses, the inability to prove the case. So when we're looking at guilt and innocence, it's not as clear cut or black and white as it's portrayed on TV. So let's talk a little bit about the different types of convictions that maybe you'll see on a rap sheet. Now, youthful offender, you shouldn't be seeing that because that is not a conviction. It's an adjudication. And the statute basically has acknowledged that young people make mistakes. We all do. In fact, I could suggest here that every single one of you have probably broken the law. Maybe not today, maybe not yesterday, but if you've ever speeded in your car, if you've used your phone in the car, didn't stop at that stop sign long enough. You didn't put your blinker on 500 feet before you turned. You've broken the law. Did you know passing a federal mail truck on the left-hand side? That's a felony. Does anybody really get charged? No. Is it a real victim crime? No, it's a safety issue. But these are the types of things that can happen to people. And then there are obviously much more serious crimes, misdemeanors and particularly felonies that have different statuses. But when we're talking about youthful offender, this is not a conviction. The legislature has said young people make mistakes and we're going to give them a second chance. So this should not be reported to you. It's technically not sealed. And you should only be getting this if you have some kind of authority for a heightened background check. There are certain educational licensing requirements that will require someone to disclose youthful offender. But other than that, if you see that on a rap sheet that someone got youthful offender and it was reported to you, that a background check is really inappropriate. Then we have cases such as ACOD or ACD, sometimes you see, is an adjournment and contemplation of dismissal. I apologize, not of conviction, it's of dismissal. That's an error that I'll fix before they share the presentation. The person never takes a plea. The case is adjourned for a period of 6 months. And as long as they stay out of trouble, case is dismissed and sealed. You should not be finding out about that. The district attorney deemed it appropriate for the person not to have to plead guilty to anything. It's probably their first time in contact. This is a common adjudication for that first time theft charge, first time possession charge. If the person, starts some treatment, maybe takes a class, there are reasons why this is offered. Again, remember, most people coming to the system first, second, third time, they're not pleading to top charges. They're getting some kind of plea bargain. The next category would be violations. And these are non-criminal offenses, and they're supposed to be sealed. Now, there are reasons why the district attorney may ask someone to not seal, to waive sealing, and then you would be able to see the higher charge that they got the reduction on. But remember, the district attorney has made a thoughtful decision to give the person a violation. The most common: disorderly conduct and harassment. Disorderly conduct means on a date in question, you engaged in behavior serving no legitimate purpose. We could all be guilty of that on any given day. Cursing in your car at the person that just cut you off could be considered disorderly conduct. When we look at harassment, that is harassment is with the intent to annoy or alarm. You either threaten to make contact or make actual contact. So if you come up to someone and kind of, tap them on the shoulder, that's enough for a harassment violation. Or you say, you threaten, I'm going to kick your butt. That's enough for a harassment violation. So we're not talking about sensational crimes here. We're talking about minor offenses in the law that we have, as a society, have said, listen, you shouldn't engage in this behavior. But the reason they're supposed to be sealed is because we don't want people to be constantly stigmatized for these little indiscretions, I would suggest. And this is not a criminal conviction. So when the client is asked about criminal convictions, they should not have to report it, just like the ACOD as well as youthful offender. Then we get to crimes, and these are crimes that are categorized by the legislature. And we start with misdemeanors, and there are penal law crimes, and then there are vehicle and traffic law crimes, but they both will show up on a background check. B are lower level, punishable by up to 90 days in jail or up to 1 year of probation. A is a little bit higher of a misdemeanor charge, and you can be punishable by 1 year in jail or 3 years of probation. And attempted A drops a charge down to a B. So attempted assault, attempted petit larceny. So sometimes you'll see that as the final conviction. Realize that when you're looking at rap sheets, you're going to see all the top charges. Many times, sometimes you'll see 4 or 5 charges, but a person will plead to only 1. Again, the district attorney has made a thoughtful decision that this person should only be found guilty of 1 out of the 5 charges or 4 charges, and they have dismissed all the others in satisfaction to that plea. That means something, because there are times where the district attorney will not offer a plea bargain, and a person will either have to plead to everything through a bargain with the judge for a particular sentence, or have to take the case to trial. So if the district attorney is making thoughtful plea bargaining offers that clients are taking, that's something to be considering. Then we have the dreaded felony conviction, and everybody thinks felonies are these very, these very serious charges, and they are, in the sense that they affect people's lives almost forever. But the reality is that they are categorized by the legislature as violent versus nonviolent. There does not have to be any violence in the act for it to be deemed violent. So let me give you an example. If I break into a warehouse to go steal something, because burglary is entering property with the intent to commit a crime. So let's say I break into a warehouse, I'm going to steal one of their box TVs. That is a nonviolent burglary in the 3rd degree. It's a D felony. The max sentence I face is on a first offense would be 3 to 7 years. Now, my first time coming into the system, I probably wouldn't even plead to that felony. More than likely, I would get offered maybe some interim probation, or maybe I have a drug problem. I'll get a drug treatment court offer where I'll get a reduced charge at the end. But the chances of me on a first time really coming in and having a plea to that charge are very, very limited. But let's say now I break into your house. You don't have to be home. I don't have to use a weapon. That is a violent felony, burglary in the second degree. Now I face 5 to 15 years, just by the categorization by the legislature. Now, technically, there's no violence in that burglary in the second degree when I break into your house, but because I have broken into your home, that's why it's categorized as violent. So we have to be careful when we see that. And on rap sheets, the initial charge could be deemed violent, but it's the conviction that matters. And many times that violent charge is not what the conviction charge is. And it's deceiving. You'll see violent felony offense and it'll go, it'll talk about an assault too, but the client pleads to a misdemeanor of assault, which has no violence a categorization. So it's important to understand rap sheets in a better context so that you can make the best decision when you are considering people for employment. The lowest level felony is an E, and then it goes up in different degrees as D, C, B, and A being the highest. A has the most serious consequences, and we're talking about serious drug possession, large quantities, dealer amounts. We're also looking at A and B felonies with manslaughter, murder charges. That's where we see the highest charges. C, D, and E are on the lower level of felonies, but they can be serious, and it's important for your human resources folks to really be able to read a rap sheet and understand what it means. And I'm always happy to help people with a rap sheet, reading a rap sheet kind of workshop. Reach out to me, and I do it for free. So I'll consult with people so that you're in the best position when you're hiring, so that you're not illegally discriminating against people. 95%, remember, of plea bargains results in that plea bargain. So many people, when they come in, even on those felonies, they are offered much lower felonies. And even people who are innocent or people who have mitigating circumstances or defenses may still plead to a felony because there's something we call the trial penalty. And you can wind up with a much harsher sentence. As I showed you, between the violent versus nonviolent in a burglary situation. But we had a client who their father came in after he was sentenced on a trial. He was charged with drugs, 3 drug sales, and he was offered to plead a 1 for 15 and a 15-year sentence. He chose to exercise his constitutional rights and be found guilty beyond a reasonable doubt, making the state stick to their burden of proof, because the state has to prove us guilty. And after he was found guilty, he got 33 years. That's what we call the trial penalty. And people are scared of it, especially when you have conservative juries in Suffolk County. So people are scared to take cases to trial, and you have a lot of misinformation due to what people expect to be at a trial because of Law and Order, CSI, and other shows that depict a court system that is basically illusory. That's not really what happens. And if you or your family members have ever been involved in the court system, it doesn't play out like CSI. Nonetheless, when people can bargain, they can also receive different types of sentences, especially if they're out of custody and they start drug treatment, they stabilize their mental health, they stabilize their housing. And then we can get people into treatment court. There can be probation instead of jail or prison sentences. There are fines that can be paid and conditional discharges. So let's talk a little bit about those different sentences when you see them on a rap sheet, so you understand them a little bit better. So if someone gets a conditional discharge, it'll say CD as their sentence. And that, depending on the level of the charge, on misdemeanors, it's going to be 1 year. And on felonies, it's generally 3 years to basically stay out of trouble. There's usually no direct supervision, but if the client is required to continue to participate in a particular drug program, and the DA would then follow up on that, and if they don't, they could then violate that. If it's a DWI, it'll include that they install interlock in their vehicle. Now, if you pick up new charges while this period is pending, not only do you face the new charge, but they can restore that charge to the calendar. And now you have already pled guilty. So now you face just sentencing on that original charge. So if you do have a person that comes in and they're still under a conditional discharge, you do have the right to scrutinize that, because technically there's still that possibility that they could be violated. But that in and of itself is not a disqualifier. It depends if there's a logical nexus between the job they're going to do and that conviction. And we'll talk a little bit more about that. Then you have people that go on probation. For misdemeanors, it's generally up to 3 years. For felonies, it's up to 5 years. And that's community supervision. And note that there are times where you'll see that there was an early discharge. That means the person did so well on probation, they didn't need to stay the whole sentence. That should be something that you're considering, that this person did so well on probation, there was an early discharge. Now, if someone doesn't get an early discharge, that does not mean they didn't do well on probation. In fact, if they don't do well on probation, you may see that there's a probation violation listed on their rap sheet, as well as a resentencing, which could be going back on probation if they get their act together, but it could also show a jail sentence or a prison sentence after they violate probation. And those are things that should be explicit on those rap sheets. And I highly recommend that you get the rap sheet from the Division of Criminal Justice Services. They are the best ones that you can get. They only cost $13.75, and through Identigo, which is the agency that contracts with Albany, and they're done by fingerprint response, and it's the most comprehensive and the best reporting when you get that rap sheet. It's the most accurate and still have mistakes on them. Now, when someone's on probation, they have to initially go weekly to the probation office. They're going to their houses are allowed to be searched. People can go to their homes, they can go to their schools, they can go to their jobs. There are alcohol and narcotic conditions, usually every week, at least for a certain period of time, and then they may become more random as a person is doing really well and has never tested negative. Some people don't have alcohol or narcotic conditions on their probation. So we shouldn't assume just because someone is on probation that they do have alcohol and drug problems, because we don't know what the terms of their probation was. And these are things under the correction law that we need to be making inquiries about when we are screening people who do have criminal convictions. Again, we'll talk a little bit more. Usually they're required to participate if they do have drug or alcohol problems in drug treatment programs. Maybe they're going to participate in anger management. If it was a crime with domestic violence, there could be batterer programs, different things like that. But remember, if they successfully complete those programs, they are deemed rehabilitated to an extent, and that should be given consideration too when we're looking at how long ago was the crime, did they successfully complete probation. Even understanding what the sentence is means something when you are screening applicants for jobs. Then there are alternative sentences. I explained that ACOD, the adjournment and contemplation of dismissal. Remember, the district attorney is consenting to taking no plea, not admitting guilt to anything. Yes, fines sometimes are just the straight fine, and it'll say whether the person paid the fine or not. If you see transfer to collection, they didn't pay that. Now, there's lots of reasons why people don't pay. They can't get a job, or they didn't have gainful employment, and now the criminal conviction is preventing them from getting that job that gets them the money to pay it. And that will sit in judgment for quite some time, collecting interest. Sometimes people are required to do community service hours or other counseling programs. TASK, usually with a conditional discharge, you might see TASK, which is a treatment program through the courts. And then there are specialized treatment courts, such as drug court, mental health court, human trafficking court, veterans court, and youth court. These are all programs designed to reduce the stigma. If someone successfully completes these programs, they can get a reduction in their original charge and what they pled to, because they rehabilitated themselves. So that's the kind of things that we want to be talking to clients about when we are talking about their rehabilitation. Let's say once you are alerted that there is a criminal history here. And then, of course, yes, some people go to jail and or prison. And there are some cases where there's not going to be any leeway for these other programs, especially with the more serious charges. Now, remember, misdemeanor for a violation, people can go to jail. It's up to 15 days. It's usually if they're serving a sentence for something else. And prior to bail reform, people who were charged with violations would get bail that they couldn't afford. And we did see people just finish up, do short jail sentences. We see that a lot less now. On misdemeanors, up to a year in local jail, it can be a split sentence, meaning they get 30 days of jail and then probation. And then there could be community service in lieu of those jail sentences. Felonies the same way. There can be a split jail sentence up to 6 months jail and that 5-year probation. They could get community service in place of that jail sentence. And there can be local sentences. So if you see up to 365 days, they probably stayed local. But then when you are reading a rap sheet, it will say whether someone has gone to upstate prison, and there'll be a whole list of information about the prisons they were in, as well as when they were released to parole. And then there are mandatory minimum and maximums for certain categories of people, such as PFO, which is prior felony offender. That's someone who has a conviction for a felony, and then within 10 years picks up gets another conviction. They're considered a PFO, a prior felony offender, because now they have 2 felonies on their record within a 10-year period. And then there are still alternatives that people with felony charges. We have JDP, the Judicial Diversion Program. We have specialized treatment courts for felonies. And for those that do have to complete prison sentences, people will be on parole. They're being supervised. Parole is just like probation in the sense, with more stringent rules. Many times when people come home from parole here in Suffolk County, they might not be allowed to drive right away. They may have curfews. So it's really important, if you are going to work with this population, that you have some flexibility. And and if someone's a really good worker, you can help advocate for them and vouch for them that they are at the job site till 7 o'clock. That sometimes can get a curfew extended from 5 o'clock, so that the client can leave work at 7 and then be able to be home by, let's say, 7:30, because they're very stringent in watching, making sure that we're supervising the people's time, especially when they first come home from prison. So now, are there any questions so far before I start to talk about post-conviction relief?
Chat right now. If anyone has any, feel free to write them in the chat though.
All right, thank you, Haley.
You're welcome.
And feel free to interrupt me if something comes up that's relevant to what I'm discussing about. So now, people come through the system. Now we've talked about some of these charges. We've talked about what some of these sentences mean. But what happens if your client said, an applicant says, well, I have post-conviction relief. Well, what does that really mean? Well, let's talk a little bit about that. So in New York, people with criminal convictions, have a very hard time achieving gainful, meaningful employment, especially when they have felony convictions. And it can also impact their ability to get educational licenses and certain certifications. They need certain types of post-conviction relief to even be considered. What's important to know is that we can't just expunge records in New York State. There's no expungement except for, now limited under the new Marijuana Regulation and Taxation Act, or MRTA, those low-level marijuana charges, which were decriminalized in 2019, now will be expunged off records. But I'm going to tell you, they're still showing up on current records. I received a rap sheet yesterday from DCJS, and it still had this woman's two of her marijuana violations were still listed. So I can assist her in getting them removed so that they're not coming up, because one of them wasn't sealed, so it would be available to be seen by employers. And depending on an employer's kind of position on marijuana, that could be a real problem for her getting a job in the future. But there is post-conviction relief in the form of certain types of certificates, as well as sealing motions. And if the case is sealed, you should not be finding out about it. But again, there's so many background checks available that can really contaminate the rap sheet, and it's inappropriately reported, but once you've seen it, you really can't unsee it. But there are certain certificates, and they will be recorded on the rap sheet if it is from DCJS, that is an acknowledgement by the court of conviction or the Department of Parole, depending on what a person's criminal history is. They basically are the same types of certificates, but depending on the history, which one they're eligible for, that acknowledge the person has been rehabilitated and they should no longer be precluded from certain types of employment. And we can specifically ask for certain types and for certain types of educational licenses. So a certificate of relief from civil disabilities is for a person with up to one New York State felony if they did not go to prison on that felony, okay, and they have no other charges. But and for a person with any number of New York misdemeanor convictions and up to that one felony, they can get a certificate of relief from civil disabilities for each charge. And many of the clients have multiple charges, especially if they were in the droves of their drug addiction. Many people in a short period of time can accumulate many possession charges, petit larceny charges. And, petit larceny is up to $1,000. So a person who steals, I've had clients steal a loaf of bread and a jar of peanut butter charged with a petit larceny, as well as someone who goes into Home Depot and tries to steal a hedge clipper for $400. They're both petit larcenies, okay? But if we don't know what the underlying facts of that petit larceny was, someone who's stealing bread and peanut butter, you may have a different view than the person who went into Home Depot and stole a hedge clipper. Not that I want to devalue people, but that to me is a little bit more serious than the person stealing bread and peanut butter, but it's still the same charge. So again, thinking about those things when we are looking at rap sheets. Was there a question, Haley?
Yes, there's a question. Someone's asking, why can't records be expunged in New York State as opposed to other states?
So of course we would love that. And I'm certainly an advocate for that. But there's been no legislation for expungement proposed. However, there was clean slate legislation proposed. It passed the Senate. It did not even get to the floor this past week in the Assembly, which was extremely disappointing. It would not expunge records, but it would automatically seal them 3 years after a misdemeanor, 7 years after a felony, provided the person completed their full sentence. So they can't be on probation or parole. They can't be serving any current jail sentence. They can't have anything pending when they become eligible, and sex offenders were not included in that. The unfortunate reality is that we're hoping they bring it back to the floor because we do believe the votes were there. However, given the political climate and I would suggest kind of distorted perception of crime, especially with bail reform. And I just like to mention that crime is up everywhere, even where bail reform was not implemented. But that has become like a political hot topic, and people are frightened. I think that the people in the legislature were a little concerned that if they voted for clean slate to automatically seal records after that 3 or 7 year period, that there could be backlash at the voting. So unfortunately, I guess their political positions are more important than the 2.3 million New Yorkers that could benefit from this relief. Sorry, but nonetheless, it didn't get to the floor. Expungement would be amazing. We do see states like California, Michigan, who have these clean slate policies that really can dramatically change people's life. But right now in New York, we just don't have it. There are limited sealing options that I'll talk about, but there are very few people qualify and very few people are seeking it. If you find clients that need that help, I run a free program that can help them file for these things. So this is a one-page application filed for each charge. It goes back to the judge that convicted him if they are still on the bench. If not, then it goes to the next judge who took over their caseload. Once it's filed, probation does an investigation for the judge. So probation's right, even if they were never on probation, probation writes a report talking about the rehabilitation the client has engaged in, and they will make a recommendation to the judge, and the person will get an actual certificate. So if you're interviewing someone and you found you found out about their criminal conviction, and now you say, okay, well, under the correction law, I want to know what you've done to rehabilitate yourself. if they have a certificate of relief from civil disabilities, which is specified in the correction law for Article 23 for purposes of hiring people, that should be given very much a lot of consideration, that the court has deemed them rehabilitated. And you could get yourself into some trouble if you just blanketly deny this person employment because of their criminal conviction. And it will be reflected on the rap sheet if they do have these certificates. Now, a certificate of good conduct it encompasses an entire criminal record. It's for a person who went upstate, has more than one felony, even if they never went upstate, any number of misdemeanors, and it will include out-of-state charges and federal charges. New York will grant relief to a person's entire criminal history. It's also used for people who are seeking public office, which in New York City includes police and firefighter, or if you want to run for any kind of town council. It's a 5-page application submitted to the Department of Parole, even if they've never been on parole before. And part of the application process, that a parole officer is going to do a home study. They're going to go to this person's home and they're going to meet with them. The application is extremely thorough with a 2-year history of employment, who they've lived with, where they've lived, and it's a review of any of their out-of-state or federal probation and or jail or prison sentences. Again, if they're granted, they're going to get an actual certificate that they're going to want to show you during the interview. And again, it will be reflected on their rap sheet. So if you see certificate of good conduct granted, it generally says to remove all bars of employment. All right. But again, you still have a little bit of leeway depending on the conviction charge. And we're going to get into that. But that, again, is an acknowledgement by the state that this person's been rehabilitated and you should give them consideration for certain types of employment. Realize that if someone gets a certificate of good conduct, it's not easy. All right, it's not something that's given out like candy by any of these certificates. For certificates of good conduct, the person, first of all, has a waiting period of 3 or 5 years from their last conviction, even if that last conviction was not a felony. So sometimes you have a person with a felony 17 years ago, they pick up a misdemeanor maybe last year, and now they have to wait 3 or 5 years before they can apply all over again. So if they get it, there's been a period of time they've been out of the court system, and they've substantially complied with everything that was asked of them by the state. Additionally, every fine and restitution must be paid in full, and they have to prove how they've supported themselves for the last 2 years, because the Department of Parole wants to make sure that they have legitimately been either working, or if they were on public benefits, or if someone was supporting them, there has to be sworn affidavits that their mom was providing all shelter and food for them, and not that they were working off the books, which is a violation of the law, or that they were doing something illegal like selling drugs or something like that. So there's a thorough investigation. Remember, these certificates are quite a task. So if a client has one, it's meaningful, any of these certificates. Now, there are other possible remedies that you honestly shouldn't even know the client has. There are conditional sealing motions for clients with certain drug and drug-related criminal cases, that if they participate in some kind of drug-sanctioned drug court or court-sanctioned program such as TASK, an alternative to incarceration, JDP, they can get their cases conditionally sealed, which means you shouldn't find out about them, because the legislature has determined that if someone does an alternative to incarceration program related to their drug issues, which is a disease, we should be able to reward them by sealing that case and not having it public. What's important to know is that it's conditional in the sense that if a person does relapse, pick up new charges, it gets unsealed. And if they are convicted of new charges, this case can never be sealed again. So if someone is still struggling with their sobriety and picking up or relapses in their bad decision-making and poor decision-making and get convicted of new charges, you're not going to be the client's not going to be shielded from those past sealing cases. You're going to find out about it, and you'll see then that someone has a history with struggles, and poor decision making. Now, in 2017, a new ceiling law, and this is really the best remedy for people if they are eligible, but many people are not eligible. Less than 3% of the eligible people have filed, but it can be up to 2 convictions. One can be a felony as long as it's non-violent. So people with violent felonies are not included. And it has to be non-sex offending. And most of the time, sex offenders are on registration lists for a minimum of 10 years up to 25 years. So even if there was this, the new clean slate, though people with sex offense convictions are not going to be eligible. But and it's important to understand too that not all sex offenses are equal, in the sense, I had a client who was 19 and was having relations with a girl he thought was 18. She was not 18. Legal age in New York is 17. It turned out she was 15 and was lying, and he got her pregnant, and that's a statutory crime. That's rape 3, and that's a sex offense. That to me is not the same as someone who engages in forcible compulsion, or someone who's much older with a child. That there are different degrees. But of course, we have to be mindful of the sex offender designation and what it means for the employees, the other employees at your job, as well as the clients you're going to serve. And again, you have the right to scrutinize that. But for warehouse work, or working on the phones, not having direct contact with other employees or customers, someone might be appropriate. And we need to understand a little bit more what those convictions mean. For the person with 1 felony, non-violent, non-sex offending felony, and 1 misdemeanor, or 2 misdemeanors, and that's it, their whole entire life, and 10 years later, they can file to have their entire record sealed. So we're not sealing records on people who have, a long history of offending. We're not sealing records for violent crimes and things like that. That is why you shouldn't know about it. And if someone doesn't report it and they say, well, that was sealed, you shouldn't know. If you've been able to open Pandora's box and now you discriminated against it, that's where you can put yourself in hot water. There's also a new law that allows for someone who did not get that youthful offender back when they committed their crime to now seek it. It has to be 5 years past the conviction. And that may now convert their conviction into a adjudication. And again, you should not be finding that out, because if people are given these special considerations for their charges, it's because the legislature has determined you don't need to know about it. It's not relevant to the work that they do. Now, if you have permission to seek those higher, more scrutinized background checks, unsuppressed background checks, because of the type of work that you do, that's different. Okay. And the client must consent to those background checks. And there are reasons, if you have special government contracts, or you going to work in a schools, Department of Health are going to scrutinize very differently than run-of-the-mill private employers. So when I talk about our clients been rehabilitated, what am I really talking about? Well, for all of this different type of relief that I've just talked to you about, there are things the court, the Department of Parole, probation, that and the sealing motions need to include. And this is a non-exhaustive list, but what I encourage clients always to get is if they've done any kind of schooling, training programs. I always encourage them to go to the Department of Labor. There's a myriad of programs. Go to their local libraries, especially if they've been out of the job market for a while. Build up a skills resume, learn computers, because every job now has some kind of data entry, related work. So these are things that people can do to enhance their skills, as well as build up their resume. And it goes to self-improvement. There are people, job training, OSHA training. If people have, I'm sorry, Haley, was there a question?
Yes, there is. Someone's asking, what are the minimum and maximum ages for a youthful offender?
So youthful offender ends at midnight on your 19th birthday. It starts at 16. Okay, but then there are also some new categories. There's adolescent offender, in addition to youthful offender. and someone can get that without youthful offender. Adolescent offender just is a criminal conviction. So that's with the raise the age legislation. So you can see that, and that's for 16 and 17-year-olds and 16 and 17-year-olds who potentially committed very serious felonies. So you may see adolescent offender categorization, but that is still a criminal conviction unless they get the youthful offender with it. But youthful offender is between 16 and midnight on your 19th birthday is when that ends. So think about that. We know some of the brain science now says that our brains aren't fully developed well into the latter part of our 20s, but we stop giving any kind of special consideration once a person turns 19. And to me, that's problematic. And there has been legislation proposed to kind of expand that to 20, I believe it's 21, which would, in my opinion, be a step in the good direction. I don't know about any of you, but I know I made some poor decisions, that fortunately didn't get me involved in the court system, but we all make stupid choices when we're young. Should that be the defining moments of our lives? Heck no. I certainly wouldn't want to be, and I'm certainly grateful I did not grow up in the age where everything is on social media, that's for sure. So to answer that question, to get back to the rehabilitation though, people, any kind of job training that people take, especially in reentry, there are a lot of programs through parole. The sheriff has a start reentry program. The Department of Labor has Ready, Set, Work. So if people have invested in themselves in these programs and done well, we should be taking that into consideration as part of their rehabilitation. Substance abuse treatment, mental health treatment. If someone has a mental health disorder, that doesn't mean they can't do the job, especially if they're compliant with if they need medication and they're in ongoing treatment to stabilize. They could, one of the things, there's lots of reports that show that people who've come through the court systems become some of the most loyal employees that you have, because they are so grateful to work and to be given an opportunity. People may have taken other counseling services, such as parenting classes, anger management, domestic violence programs. So this is all taken into consideration when we're getting granted this post-conviction relief. If they had previously granted certificates, especially during COVID, I would like to just say that there are people who were sober 7-8 years from drugs and alcohol who during COVID relapsed. This was a collective trauma, and trauma affects people differently. And we've seen many people struggling during this time. I can speak to my own struggles during COVID, feeling hopeless and helpless. So imagine if you already have a predisposition to mental health issues or substance abuse issues. We saw a lot of people relapse, maybe get back, unfortunately, into the court system. But people could have been granted previous certificates. And when you're reading rap sheets, if in one of the earlier cycles, 1 or 2 or 3, you see a certificate, but then you see post charges, it might have been something that had happened in their life that unfortunately caused them to relapse into the criminal behavior that brought them before the courts again. But we take that into consideration to show that people are capable of redemption. And if they've done it once, we want to show that they're doing it again. So that's why you might see certificates on some cycles, but not on others. Letters from probation or parole can be helpful. It's usually one sentence they successfully completed, but that really is meaningful because it means that they complied with everything they were supposed to do and followed law enforcement's requirements. Character letters from the clergy, civic associations, anyone they're involved with who knows about their history and can speak to the changes they've seen in the person. That's the most beneficial letter. A letter from their mom is not going to be as strong as a letter from a current employer or someone who's known someone for the last few years. And then I always encourage clients to do volunteer work, whether it's once a month at the soup kitchen or they help the neighbor down the block. Now, what can you do legally? Can you legally deny an applicant a job because of their criminal conviction? Yes, you can. But there are reasons why it becomes illegal. So currently in Suffolk County, you can ask whether a person's been convicted of a crime. Remember, youthful offender, violations, ACODs, those are not crimes. And if you're running a background check and you're getting that information, that's inappropriate. And if you're making your decision based on that, you're bordering on illegal applications, okay? But because of the Fair Chance Employment Act that went into effect August 2020, you shouldn't be asking on the job application unless you have the special status in that Employment Act, such as schools, hospitals that go through a higher scrutiny. But your private firm should not be asking on that initial application. You're in violation of the law. So remove that question if you have it. But you can ask during the process of the interview further on. So the goal with the Fair Chance Employment Act was to not exclude people because they check a box that they have a criminal conviction. Okay, because if I can't even get into the door, I can't even tell you about my recovery, about my rehabilitation, and what I can bring to your company. It's illegal to ask about arrests, particularly because not every arrest results in a conviction. All right, there are certain agencies that can look into arrests, but for the majority, you cannot look into arrests. If a person misrepresents their criminal record, you absolutely have the right to terminate that person. Even if you may have hired them knowing their criminal record. But if they lie, that is your right to terminate them. But you're not permitted to disqualify a person solely because they have a conviction. There must be a logical nexus between their conviction and the job they're going to do, and or they must pose an unreasonable risk to the safety of others. All right, so what that means, the person who has a DWI, you don't have to hire them to drive. If a person has fraud or a forged instrument, the bank doesn't have to hire them. And if someone has drug charges, you don't have to put them in a nursing situation. If people have assault charges, you have the right to assess whether they're a risk to the elderly population you serve in that nursing home. But again, we have to look at how long ago the crime was. And there's usually that 30-day window. Now, if you offer someone a job and then retract it several days later before they start or right after they start because the background check, I hope that you've done this scrutiny to determine why you can retract that offer, because the client's entitled to make a written request for the background check that you're using, and they're going to be checking it if they've worked with me against the DCJS one to see if you have been inappropriately told something that you shouldn't have, and was that considered in your decision. And they're entitled to know why you retracted that offer. And let's say you say because of the criminal record. Which in most cases, if their criminal record is done, is the reason. And then they have the right, if they think they've been illegally discriminated against, to bring a lawsuit. They can contact their human rights commissions or the New York State Division of Human Rights to see if employers are illegally discriminating against people. Now, when are you negligent in hiring? So if you knew or should have known facts about that person that a reasonable person would have investigated, and you could have anticipated their behavior would result in injury, and so these are ends, so that you must in order to be found guilty by a jury, the person bringing the charge, the person bringing the charges, such as maybe another employee or someone vulnerable, they would have to prove every single element here, and you didn't use reasonable care to correct or remove the employee, then you could be found at fault. But if the employee was competent, we have to look at were they competent or incompetent? Did you know the facts? So are you doing background checks? Or that the reasonable person would not foresee this disposition. So someone has a drug charge. It was 6 years ago. They give you all the evidence that they've completed treatment, done all of this, then they show up to work high. It's arguable that you wouldn't have reason to believe they would have shown to work high given the period of time of sobriety, all the rehabilitative evidence. Okay, so the point of this, to show you this, is that it's a very high burden to prove that you were negligent in your hiring, but you have the right to legally disqualify people. And hopefully you have attorneys on consultation to help you guide, when you are considering this, because you know what, if you do illegally discriminate, people are advised to seek counsel from the Division of Human Rights to try to see if that discrimination was illegal. The things that you should be considering, these are the 753 factors in the correction law. All right. What's the public policy of this state to encourage licensing and employment? What are the specific duties and responsibilities related to this license or the employment that the client is going to be doing? So if a client has some criminal charges and you have, let's say you work in a nursing home, but the client's being hired for a cook position. Well, the people in the nursing home, they're not going to have contact with the people in the nursing home. The people in the nursing home, the residents aren't going to go in the back with the cook and help them. So should that person be excluded? I've made the argument no, because especially if they've shown the rehabilitation. So we want to look at what bearing the criminal offense has on their fitness or ability to perform the duties and responsibilities of that job. How much time has passed since their last conviction? If we're looking at, 2, 3, 4, 5 years and they have other rehabilitative evidence, you should give that more consideration than someone who was just in court several weeks ago, obviously, okay? The age they were when they were convicted. Is this someone that was convicted in their youth? Because all the studies show us that criminality really starts to level off when people get to the latter part of their 30s, if they've been involved in the system before. Any information produced by the person or on their behalf regarding their rehabilitation and good conduct. All right. And you see in number 2, certificates of relief, certificate of good conduct. That's shall in the law means must. Must create a presumption of rehabilitation in regard to the offense. So if you're relying that the court or Department of Parole, because the client has given you these certificates, that will negate your negligence in a suit down the road, because you shall create a presumption of rehabilitation. You can rely on those certificates when you're making your assessment to determine whether you should take a chance on this person. What can you do to reduce your liability? Federal bonding program, all right, to help that high-risk applicant. It's basically a business insurance policy provided through the Department of Labor, all right, starting at $5,000, but you can get up to $25,000, but that needs to be negotiated and it requires justification and approval by the Department of Labor. But let's say you work with really expensive equipment, all right, and that's where I've seen it come into play. And you want to take a chance on this person, but if they mess up, that's a lot, that could put your business in jeopardy. That's something you would discuss. This is given to you, this insurance policy to cover losses up to $5,000 or higher if you negotiate it, at no charge to you, no charge to the employee for the first 6 months of work. Now you can renew that for a fee after 6 months, but think about that. You're basically getting an insurance policy to give this person a chance. And I think you will be 9.5 times out of 10, because there's no guarantees, you're going to see someone who comes in who is loyal, works hard, doesn't call in sick, and is ready to work. They've been training with the Department of Labor or in other job services. Maybe they've gotten a certification. They want to work. And the number one predictor of whether someone will recidivate or not, commit a new crime, is gainful employment. There's a certain sense of pride. There's a certain sense of dignity that comes along with the idea that I can support my family. I have somewhere to go every day, and I am a contributing member to society. You can help make that happen. This can be granted. So it's not going to be given to those with poor credit, and or fraudulent or dishonest acts. So they're already going to weed certain people out. So when you're thinking about this, it can be for full or part-time work, temporary to permanent positions, and it could be given to someone you're considering for a promotion. Maybe you don't do that background check when they first start. You really want to make them a manager now, but there's a more increased scrutiny. Now you can get that insurance policy for them. Don't exclude someone just because they have that history and maybe they're going to be more heightened background check now, because you might have an option for them. If they're a good employee now in this new position, they may be wonderful. All right. Speak to a Department of Labor representative if you want more information. There are tax credits that you can get. Work for Success is a state program that'll give you tax credit for qualified applicants. As I mentioned, there are studies that show longevity in staff who have criminal convictions. It reduces recidivism, so you're helping our communities, and that really makes families and our more stable and our communities safer. The fact that you're even here shows that you're giving this a thought if you haven't already hired someone, and that's really does take courage and compassion. I hope that this presentation has kind of given you a little bit more context to understand. If you would if you would like for me to do a training for your office or your HR about reading rap sheets, I can bring some redacted ones in. We could talk about it. And if you want information on how to get that official rap sheet from DCJS, which is really the one you should be using, please let me know. I'm happy to share my email. But I really hope that this maybe will give you an opportunity to expand your hiring circle and give people a chance to prove that they are worthy, they are capable of redemption. They're some of the nicest people I've ever met, and they are so humble and so grateful to even be given an opportunity to interview. So thank you for taking the time today.
There is just one question in the chat. Someone is just asking, how often are employers found guilty of negligent hiring?
So we could not find any recent cases. There was, I think, one from 1976. But the laws were different then. We couldn't find anything currently, to be honest with you. Now, obviously, if you're running a child care center, you don't have to hire a sex offender. There are just reasonable things that no one's going to expect of you. But you have to be willing to take the leap for that person. I'm sorry, what is the law for adding your record? I'm sorry, that came up. I'll address that in a minute because I'm not sure on the question. But we've had very few. In fact, most of the lawsuits are brought against businesses who don't hire. That's where we saw. I had a client who come in. I forget if it was the New York State Division of Human Rights or the Suffolk Human Rights brought a lawsuit on his behalf, and FedEx has now changed its policies, but they hired him. He was working for 3 months, tons of overtime. Then they ran the background check and he had a felony. He had disclosed it to them, but they said, well, we can't keep you. And he went to the Human Rights Division. He was working with us to get post-conviction relief. And what happened was they were found to be illegally discriminated against, and they were fined. He got a $10,000 settlement. Now that's not a job, but it kind of cushioned him while he was out of work. And now we've seen FedEx change their policies. We've seen a lot of employers change their policies, giving people opportunities. Again, you have the right to definitely scrutinize people's backgrounds, but you need to know what you're looking at. You need to, and you have the right, if you're on like the cusp, some employers will ask, can you get me details about the crime? Because not all are equal. Remember that petty larceny. Did this person steal bread and peanut butter? Or did this person steal property from somebody's house? I mean, these are different things. And if you're working with vulnerable populations, you have the ability to distinguish between that. But the mere fact that someone was in possession of drugs, well, what drug was it? Was it their prescription Xanax pill that they had out of the bottle, which was charged as a possession? Or was it, several bags of heroin? These things matter. And has this person done rehabilitation, which again, under that, the 723 factors is what you should be considering. That's what could make you liable if you haven't properly looked at that rap sheet. And I'm just going to type my email in the chat for folks. Feel free to reach out to me privately if you would like to. And I can certainly, again, I'm happy to run a workshop for HR folks on reading rap sheets or anyone. All the presentations that I do are free and I'm always happy to share. And if anyone wants to talk to me further, I have probably 300 current clients going through post-conviction many of them are looking for jobs. I can certainly refer people who we could talk about. And of course, I do a lot of work with the Department of Labor. We share a lot of clients in common, and I always encourage them to go to to the, oh, thank you, Haley. I didn't realize I did a direct message. Sorry about that.
That's okay.
But I do a lot of work to try and get people, in better positions, and the Department of Labor has done a tremendous job in this area. So I thank them for all the work and support they've given clients that I'm working with. Does a job applicant have to put their criminal record on a resume? No, and arguably they shouldn't. What happens though is sometimes when you have people out of prison, they sometimes will put the prison name because they've done work there. That's, I don't know how the Department of Labor handles that in the resume writing. They're more of the experts to discuss that, but there are meaningful types of employment you can get at prison. People do barber work, they do custodial work. I had a guy that became, he did 31 years for a murder charge when he was 19. He was involved in drugs. Him and another person went to rob a drug dealer. The other person shot them. That's felony murder. Even though he didn't pull the weapon, he got 25 to life. He did 31 years, but he made, he took that time, learned how to become a mechanic, became the top mechanic for all of New York State's prisons, and actually got a certificate of good conduct upon release, got hazmat certified through the state. He did every program imaginable. When I sat down with him and realized his charge, I was shocked. He was the most humble and nicest man I had met, because his crime was when he was 19 years old, a drug addicted 19-year-old. I was meeting a 50-something-year-old man who had tried to make the best of his time while he was in prison. And he was still struggling to find a job despite all these certifications. And he just needed someone to help him through the door. And we worked with him, and he got a job at a good company. And I've worked with folks at DOL to advocate for clients when they are denied initially employment or get that 30-day window to put packets together. We've worked as a team to really help people get those meaningful jobs, but they shouldn't be putting it on a resume. If you do background checks, that's your right. And for certain types of jobs, you should be doing background checks, especially if you serve elderly or vulnerable populations. You want to potentially screen people out because you could be found negligent if you don't. But the reality is, if you're using the tools that we've given you here, and if you have any questions and you don't have a lawyer on consultation, I'm happy to talk to you about it if you have questions. And of course, rely on the DOL and the federal bonding program that can really help put in some, if they get bonded, then the federal government has determined that they're worthy of this opportunity too. So think about those things when we're talking about people and giving them those opportunities. Any other questions or comments? I went a little bit over. See, I didn't even think I'd use the whole hour, but I'm a lawyer, so I can talk, right? But I thank you so much for the opportunity. Again, reach out to me if anyone, if you have any questions. Thanks for joining today.
Thank you so much, Liz, and thank you everyone for joining. And we will be sending this presentation to everyone who registered and posting it on our website. So enjoy the rest of your day. Thank you.
Thank you. Bye-bye.
Bye.